All right. The last case for the morning is KAJAINE Estates versus U.S. Bank. All right, ready?
Good morning, Your Honor.
Morning.
Your Honors. May it please the Court, James Doherty here for KAJAINE Estates, LLC appellant. I'd like to reserve 5 minutes, if I may. Would you like me to go into the facts or go directly to argument?
Go to the law.
In this case, appellant's motion to intervene, reopen, and return the original documents should have been granted. Original loan documents delivered to the appellant. Even then, the appellant, KAJAINE Estates, would need to make all required arguments for standing to successfully foreclose. Standing is normally an issue to be determined at trial or after the filing of a new case.
But if the trial judge found that the predecessor, Condor, never owned the note and mortgage, never owned it, and then later on sells something that it never owns to your client, why would the trial judge then have to let you get the original note out there when you never actually, when you bought it from somebody who never owned it in the first place?
Well, Your Honor, we went to an original hearing on that issue, and we were asked to return and provide evidence and to show if, and in fact, if our client could connect the dots for Condor. So whether we could show standing by and through our predecessor in interest, Condor Capital. So that is indeed what we attempted to do, was to bring Mr. Anand Patel back to the court, which was in April of 2015. Mr. Patel was there. He had filed an affidavit of ownership in the case. We had also shown affidavits of ownership, a sale and purchase agreement. A valid purchase took place between Condor Capital and the appellant. These instruments are presumed valid under statute 90.902 in the Uniform Commercial Code, unless evidence is presented to the contrary. The assignments and endorsements are also presumed valid under 673-3081. Appellee speculates what evidence could have been offered by Mr. Patel that day and whether the affidavit filed is admissible, even if it's not. The actual testimony of Mr. Patel, the contents and facts contained in that testimony, would be admissible due to his presence there.
Well, how does he prove that Condor owned the note so that he was able to buy the note from Condor?
Mr. Patel is a very sophisticated gentleman. He also is the owner and principal of KAJAINE Estates. They buy and sell notes on a regular basis. Part of what he does is performing this due diligence. He also visits with individual lenders. He is personally familiar with some of the individuals who were actually signatories on some of the assignments. So we're dealing with a different type of a client here than I would normally be dealing with. He's actually got personal knowledge of some of these.
Because I still haven't. I've been waiting for an answer to the question and still haven't.
Yeah,
I'm sorry, Your Honor.
Yeah, that's not really an answer. You saying that my client's sophisticated and he knows these people, that really doesn't say how is it that he proved that Condor owned the note. I mean, wouldn't you have to have the Condor person to somehow explain how he or she or it acquired the note, or from whoever up the chain? I mean, it seems like the problem initially is when the suit was filed, there was no endorsements to the note. So it showed Bravo was the entity.
Yes, Your Honor.
That was the original lender. Somehow somebody had to connect the dots at the time of inception of the trial, of the lawsuit, how U.S. Bank had standing. That seemed to be, might have been a problem in this case, but it's still, I'm still not clear how it is that your client establishes to the satisfaction of the judge here that Condor actually had something to sell.
Well, we believe that he could, based on business records exception and his knowledge of what happened even prior to, I would say that he had a better knowledge of the history of the case and the parties than Mr. Green did for Condor. the truth is, we don't know what he would have testified to because he was not given the chance. And I believe that's a major point I'd like to make for the court, is that he was asked to come back and provide, we were asked to come back and provide testimony or evidence. We brought back all the evidence we could, including Mr. Patel himself, offered Mr. Patel to offer evidence that day, which
Mr. Patel is your principal.
was the principal of KAJAINE Estates, yes, Your Honor.
Okay.
So we don't know what he would have actually been able to say that day. If he did testify,
Well,
Mr.
and the trial court would not allow him to testify?
I offered it, and he was not, no one asked him to take the stand.
No one asked him to take the stand.
You said, Judge, I'd like Mr. Patel to take the stand, and
I asked the judge if it would make
quiet
it,
from that point?
I'm sorry, Your Honor. I asked the judge if it would make a difference if Mr. Patel take the stand, and he said no, that he didn't believe that it would make.
So did you say, Judge, I'd like to proffer the testimony?
I don't believe I actually stated it that way, Your Honor.
So if you want to preserve the failure to allow a witness to testify, what do you have to do to preserve that issue for appeal?
Well, Your Honor, I would.
Give you a hint.
Don't you have to do that? That's kind of.
I would think that I would need to make some sort of a statement. However, Your Honor, I believe that his appearance there,
No,
and
that's not good enough.
If the trial judge says, I will not listen to your proffer, then you've got something. Because obviously, what else can you can't make the judge sit there and listen. But if you say, Judge, I believe this evidence is relevant, I would like to proffer the evidence for you to consider before you don't allow my client to testify as to his ownership of this note.
Or even proffer for the purpose of subsequent appeal.
one moment, Your Honor, if you would, I believe I do have some testimony that may clear some info from the proceedings that may okay. Your Honor, this is in the record, volume 3, page 397, and this is myself to His Honor. Well, Your Honor, my client can't connect the dots, however, he can do so for KAJAINE Capital. He's not here for Condor, but he can connect the dots, and he's willing to do so if we need to do so today, Your Honor. If that would satisfy the court, Mr. Patel can take the stand. That is as far as I went.
No, it's not good enough. That's not how you preserve, that issue.
And let's say, even if you did, I'm not sure what it is you're going to say. Your client's going to connect the dots as to how he acquired it. He's going to say somebody from Condor and I entered into a contract, our respective companies entered into a contract where I buy this note.
Yes, Your Honor.
I'm sorry, how do you say your client's name?
Doherty.
KAJAINE?
Oh, KAJAINE, yes, Your Honor.
Right. KAJAINE Estates bought this note. And it seems like the issue that was the concern of the trial judge is that there was no indication that Condor owned the note. So there's nothing for Condor to sell to your client. Therefore, when you're in front of the judge saying, I would like a note because I bought it from an entity who the judge believes had nothing to sell to your client in the first place. I mean, how's that any different than saying, well, I want to get a copy, I want the note out of the file because I'd like it?
Well, Your Honor, I believe it would be true that even if Mr. Patel did receive it at that time, that he would still need, or his company would still need to go through and prove standing, including the prior holders.
For a foreclosure, it's a negotiable
For foreclosure.
instrument. Yeah, for instance,
In order to do anything with it.
It's not outside the realm of, for us to speculate that your client paid something to, the predecessor for the note. So it's a negotiable instrument. It has value beyond the issue of foreclosing upon it, correct?
Yes.
In theory, your client could then sell it to someone else.
In theory, they could.
If I were to go down to the courthouse and look at, if I could buy notes if I could get the court to give me notes out of a file, I could sell them, right? Without having anything to do with the foreclosure.
Well, Your Honor, that wasn't the case here, though. We have an affidavit of ownership filed, and also a copy of not only the assignments, but the asset purchase agreement. So with that affidavit of ownership, Mr. Patel is not only just stating his ownership and stating that he did validly purchase it, he's also indemnifying all third parties out there in the world against anyone else that would come forward to say that they did own it. This is every protection that we could try to provide to the court and to other parties to try to get Mr. Patel the note that he purchased. Basically, Condor was permitted to enter into the case via a motion alone and an assignment of mortgage into its name, which is normally the case. And our question is, why should KAJAINE be held to such a higher standard when trying to intervene into this case or enter into the case?
Wasn't it Mr. KAJAINE, or
Mr. Patel, I'm sorry.
Mr. Patel, on behalf of KAJAINE, didn't seek intervention to appeal the final judgment, he just wanted the note?
Just the note, Your Honor. That's all he really wanted, and there was an opportunity to appeal the final judgment by Condor prior. They did not take advantage of that.
But then how does that not apply, go back to Judge Cohen's hypothetical of his going down and asking the clerk of the court if he could just buy some notes out of the files?
Well, the difference being, Your Honor, is that, again, the affidavit of ownership filed, I believe, makes a big difference in that he's filing that and putting all third parties on notice that he's the only party that is entitled to enforce it, in fact, offering to indemnify any of those parties. That's not simply just going down and asking for a note. That's actually, he's proving that he's paid good money for it. He's also putting his money where his mouth is to say, look, if someone else comes forward with a valid claim, I'm going to indemnify them.
Yeah. Now, that doesn't mean that necessarily he could foreclose upon.
It does not mean. And he would still have to make all showings to foreclose upon that note. He could be subject to a motion to dismiss the day we file the complaint, if we were to do so. Say we got the note, we were able to file the complaint. They could file a motion to dismiss, go into Condor's, all the past, account history, ownership, payment history. Any of these things would be open to the other parties.
All right. All right, do you want to save the rest of your time for...
Yes, Your Honor. Thank you.
May it please the court, my name is Rusty Collins, and I represent the appellee, Mr. Williams, in this case. I took this case...
Why does your client have a dog in the fight?
My client has a dog in the fight because if the court confers standing...
No, that's not what's being done.
Well...
All he's asking for is, Judge, I want this document removed from the court. That's all. It's not, he's not asking to foreclose upon it. He's just asking, I want, I've got an affidavit here showing that I'm the owner of this document. I'd like it removed from the court file. That's it.
Well, number one, he doesn't have the right to intervene. The court, the case is over.
Let's assume that intervening was in the wrong phrase. That, he files simply a motion with the court to remove this document showing an affidavit of ownership.
Because when we went to trial...
We're done with that.
I understand, but you're asking me why we have a dog in the fight.
Right.
We have a dog in the fight because if the court releases that document to KAJAINE based upon their assertion that Condor sold them the note, when Condor was shown not to have standing.
But that's a difference. See, you're equating ownership and standing, and I'm not. The fact that that the banks in these mortgage foreclosure cases barely can prove their own name, is a different issue than ownership. One's a burden of proof. So you guys go to trial, and you hold them to their burden. Say, all right, prove that you own this as of the date of the filing of the complaint, because that really was the main issue. You can't prove you owned it as of the date of the filing of the complaint, and by God they couldn't prove that from the witness that they presented. That doesn't mean that they weren't the owner of the note. All it means is that they couldn't prove standing as of the date of the filing of the lawsuit. And so you're equating ownership and standing, and I'm not.
I understand.
In fact, what the judge actually found, following what Judge Cohen's saying, what the judge found in the final judgment was Condor failed to establish that it held the note and mortgage to establish standing. Defendant, your client, wins based on lack of standing. I could have somebody who comes in and is not able to testify as to how much money is owed because it's not a qualified witness as to the business records. I may not, especially in this case where there's no copy of an endorsed note to the complaint, I now have to show why Bravo's not the proper party. I don't do that. In fact, that was kind of a lot of your argument, I think, below.
Yes, it was.
At the time. So you prevailed. All right, so now Condor says, I've had enough of this. I get this guy Patel who says he wants to buy some of my notes in Marion County and other counties, and I'm out of this business and I'm happy to sell it. And so Patel and his company come in and say they want the note, and they pay for it. You still, as Judge Cohen indicated, you still have defenses when he comes and sues your guy who allegedly hasn't paid money on the mortgage for 8 years. You may have whatever defenses you want, but to simply say the note basically is no longer in the stream of commerce because that guy who bought it can't get it out, and the people who filed suit and were the assignee who could care less don't want to spend money to get it out. You know,
They have a remedy for that. You can enforce a note that you don't have possession of if you can prove that you obtained ownership of the note from a party who had the right to enforce it, either directly or indirectly. They have the remedy to the Uniform Commercial Code.
so as opposed to saying, I know where the note, it's not a lost note, it's right there. I would
doesn't
like
have
to get it. Why can't they
The
get it?
note doesn't have to be lost in order to enforce when you don't have a possession
But
of it.
again, going back to what's the dog in the fight that you have? Why does your client care other than the longer the note's not in existence in the legal sense here, the longer your guy gets to stay in the house?
Because if they end up with the original note, then they become the holder. A thief can be a holder of a note, and
Then
so
they
they
would
have
sue
the
you.
right. They have the right to enforce.
They would sue you, and I guess you would raise whatever, your client raise whatever defenses, and
And what's the alternative is that your client gets a free house, is that it?
The alternative is my client has somebody who doesn't have an ability to foreclose based on being an
A
owner.
free house.
Very possibly.
Okay.
I have not seen a free house yet in the course of
well,
litigation.
Yeah, you're working on it, aren't you?
yeah, you're working on it.
If I find one, I'll probably never stop talking
This
about
one,
it.
you're working on this note never coming into existence, and he can't say he's the owner. I mean, they can't sue saying that they have the possession of the note at the time sued, because they don't. They can't say it's lost because they know where it is.
But they can enforce a document, a negotiable instrument that they do not have possession of. They can,
So why should they
Yeah.
go through that hoop when they can simply just get the original back, and that makes it an easier trial, an easier case?
what right do they have to it? They say they bought
They
it from
said they
some,
bought it. They bought it from the guy, from the Condor who got it because it was assigned by U.S. Bank, and the trial judge let the assignment from, let the party plaintiff change from the initial plaintiff to Condor based upon the assignment of the note and mortgage, right?
the original note was that is not a reason, because the note was placed into the court's file
Before it was assigned.
by U.S.
Well, and
Bank.
that's why you guys won.
U.S.
Job,
Bank,
well done. You defended the foreclosure, your client gets another couple years in the house, without having to pay a mortgage. That's great, good work. But the idea that, that goes forever, that there's no end in sight, that your client might, never have to make a mortgage payment, that doesn't seem to be a very convincing argument. And it doesn't seem to me that, if you're arguing, well, they can enforce the note through other means, then what's the prejudice?
I'm sorry, what's the
prejudice? If they can-
prejudice? The prejudice is if they release that note, he doesn't have to prove that he bought it. He doesn't have to prove how he got it. If he has to do it by, through enforcing a lost, stolen, or an instrument he doesn't have, he has to prove that he obtained ownership directly or indirectly from a party who was entitled to enforce it. If he gets that original note, he doesn't have to prove anything when it comes to that issue. He still has to prove how much is owed and conditions proceeding. But he doesn't have to prove that very important issue, because it seems like every case we see on Foreclosure is, we don't care how they got that note. If they got that note before they filed the complaint, they have their standing issue taken care of. And that is the crux of the argument.
Right.
Now, the other crux is, what's the review standard here? Is this a intervention case or is this a standing case? I think if we read the court's, the transcript of our hearing with Judge Nichols, and was never said, this is an intervention case, you don't have the right to intervene. However, Judge Nichols kept saying, I'm not going to mess with this other case. The dots weren't connected, how can you come in and connect the dots now? The case was over. They don't have a right to intervene in any way. It's 18 months after the case was done. They can do
Let's say
something
the
else.
judge said, you know what? We're now finishing up this trial. Mr. Collins made some very good arguments. I'm comfortable that Condor owns the note at the time of trial, but they did not prove standing at the inception of the lawsuit. Therefore, on the standing argument that Mr. Collins raised, defendant wins, final judgment in favor of defendant. Okay, then Condor goes down the road and says, okay, had enough of this foreclosure world. I'm getting out and I sell this note to the Mr. Patel. And so Mr. Patel, they sign an agreement, buy it, etc. And so Mr. Patel says, well, now I'm in the business. I want to get that note back from the court file. Can't they get it then based on these findings that I've just told you are made? And if not...
No, they're not a party to
No?
the case.
Okay, so the judge found that there's the owner. The owner now has sold to Patel. And Patel, the new owner, says, okay, I want the note back. I mean, I granted Condor didn't show standing and Collins did a great job and he wins, but that was then, this is now. Still can't get it.
If the court finds, as you said, then Condor has the absolute right to get that note.
They're the owner. They make the finding, they just didn't prove standing, which he found in your case that they didn't prove
Right.
standing.
You can obtain ownership after the case is filed and still lose on standing. They should get the note back.
Who?
Condor.
Condor says, well, I'm not going to spend money on an attorney. Well, I don't care. I sold it to that guy. Let him get
Well-
the note. Let him spend money on an attorney.
Then KAJAINE needs to go to Condor and say, you have your representations and warranties.
Okay, they're
And our
past,
agreement.
they're past 90 days under the document, under the agreement. So now the warranties are gone under the agreement between KAJAINE and Condor. So now KAJAINE, somebody says, I just want the note back, you know? I bought it. The judge recognized that the guy who sold it to me was the owner. He just didn't win his lawsuit.
Well, then they have a very easy claim when they file their foreclosure case to enforce a lost note.
All right.
All right, thank you.
Thank you, Judge. For that reason, I'd ask the court to affirm.
Okay.
Thank you, Your Honors.
All right, you've got 8 minutes left. There's no penalty if you don't use all 8 minutes.
Thank you, Judge. In the analogy that was just discussed, if Condor, quote, should get the note back, then I would argue that so should KAJAINE in this circumstance. Mr. Collins' client has no right to the note. His dog in a fight is that he wants to stop us from foreclosing. He wants a free house. Intervention,
Oh, he's not alone. Everyone wants a free house.
This
I'd
is
like
true.
a free house.
I would too.
Yeah.
Unfortunately, we were trying to stop him from getting one from our client. Intervention may have been the wrong term. Successor in interest, I think, is more accurate.
Filed it, not me. I think intervention was a poor choice.
Okay.
The law on intervention is, not going to favor, the granting of that relief. And intervention has very specific ramifications.
Understood, Your Honor. No matter what happens, we must prove our ownership on the day of filing, just like Condor did. Condor was the owner, failed to establish standing.
Do you agree that if he possesses the note as of the date of the filing, that there are various defenses that don't apply to him?
Well,
if he's in physical possession of the note?
it makes it easier to make the initial pleading, Your Honor. However, my understanding is that all defenses would still be available to the defendant as far as how we came into possession of the note, whether that's legitimate, whether it's proper, whether the sale or the transfer was proper. I believe all those matters would be defenses and items available for the defendant to raise.
And to answer my own question, it might be, why do we care at this point? Isn't that something that's going to play out later, not now? Not right
Absolutely, Your
forever?
Honor. That's our argument, is that this is something for the court later. Once the note is retrieved and then a new case is filed, then all defenses are available, and that case should run its course like all others. Most of the notes that we deal with have been transferred in the past and will be transferred again. This is just a part of the process, and we ask the court to reverse and/or remand with instructions.
All right, thank you.
Thank you, Judge. Judges.
All right, we will be in recess.